Hello. So this is the actual document of motion to dismiss. The Karen Reed, two of the charges, as I said in a previous video, that somebody had come to me last week before this was announced to the media. I don't know who this person was, and told me that it's hush hush right now, but that he won. And I thought the person was telling me that Lowley won. And, because it wasn't clarified in the comment, it was a respond to one of my comments. Nonetheless, it has come out that 3 jurors, or at least one of the jurors, contacted Karen Reed's attorney, and then 2 of them, through an intermediary, contacted her attorney. So 3 out of the 12 have contacted her. Now, I've shared in the past cases that I found in Massachusetts Supreme Court and federal courts regarding how instructions are handled when you have lesser offenses. There's some specifics on this. The thing about this particular case is that they will have to prove that this judge mishandled the jury instructions and get probably in a court, because she's obviously not going to admit her error, right? And that's just my prediction. But I pray that she'll humble herself. But they'll have to prove in this situation, when she read the instructions to the jury, if you're somebody that watched the jury instructions or did not watch the jury instructions, she said, if you come to a verdict on this, you find that she's not guilty of you starting at the highest level offense, which in the second degree murder was not anything to do with the car, but the accusation that she beat him to death, that he reserved for the very end, didn't present anything at any time whatsoever. And I shared that instruction being read to the jury in a video. And of course, they all unanimously, according to these jurors, unanimously said, yeah, no, that did not happen. And then on the next, one of the lesser offenses, also acquitted her on that. And then there was one of the offenses that's where they were split. So they had already completely agreed, according to these 3 jurors, that that absolutely no way is she guilty of 2 of those charges. And so the other charge, there was a split. Some of them felt that she had, I think it's the one where she accidentally or negligently, not realizing that she had hit him or something like that, I think is the one. But some of them, it sounds like it was evenly split. That's where the division was. It was the third charge that they couldn't. Half of them were like, they think she was guilty, and the other half were like, nope, not even buying that either. So, but at least she was completely exonerated of his desperate ploy to claim that, okay, in case you don't believe the car theory, she beat him to death. And if he was beaten to death, it certainly wasn't done by her. That's what they said. He was done by, anyways. So here's the motion. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court. And by the way, I will put the link in the description. If you don't see it the time that you see this video, just hang on. Okay, I generally upload and then edit. 5th, 6th, and 14th Amendments of the United States Constitution, Article 12 of Massachusetts Declaration of Rights, to dismiss counts 1. So it was counts 1 and 3. So it's the second one that they were hung on. Okay, so now by this right here. Now again, this is just according to the jurors. Counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges. And I don't know why the rest of the jurors aren't coming forward. They don't have to. But that may be an issue on what the upper court decides to do. They have to argue and prove that the judge erred and abused discretion in how the jury instructions were handled, and giving them so that they can understand, for whatever reason. Well, there was an accusation saying that they found out after the fact that they were reporting a mistrial, and they were like, why aren't they telling, the juror just kind of got the idea that the judge is going to let them know that they had acquitted her on 2 of the charges. The only thing that was read, the only note that was read by the jury foreperson, so we don't know if it was the jury foreperson who didn't present the information to the judge. Not really sure on that. But for whatever reason, the judge did not state that they had acquitted, but they were hung. Okay, there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty. Again, you have to argue specifically that they communicated that. That's going to be necessary before the Supreme Court. And therefore, a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. The ancient right to jury trial is no more procedural formality, but rather fundamental reservation of power of the American people. Erlinger versus United States. That was a 2024 citation omitted, 2024 case. Okay. Wow. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Quoting the Federalist, number 83. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generations sought to ensure what would happen before it would not happen again. As John Adams put it, the founder saw representative government, trial by jury, as the heart and lungs of liberty. If all the jury acquittals entitle the utmost respect in our criminal justice system, the double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees the state shall not be allowed to make repeated attempts to convict the accused, therefore subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continued staying anxiety and insecurity, as well as enhancing the possibility that even though the innocent she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy, therefore violating the Constitution. Here the very day after mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating juries indicating in no uncertain terms that the jury did have a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. That very charge that was read to the jury, that she beat him to death. I did a video showing that juror instruction being read after all the time that he said and argued that a car caused his injuries. Excuse me. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits the jury unanimous agreement and precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. On June 9, 2022, Miss Reed was charged via 3 separate indictments with murder in violation of count 1, vehicular manslaughter in violation of 265 and 13.5 count 2, and leaving the scene of personal injury or death in violation of. A jury trial began on April 16th. Now, see, here's the problem with the second degree murder. It doesn't say anything about him being beat to death. Vehicular manslaughter, count 2. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. Now, we remember that if you watch the trial. The note was not presented to counsel for review. And so there are some specific cases that I covered in one of my videos. The case that I covered was specifically not allowing the defense to see the note from the jury so that they could argue. And that was a bad move on the judge, and that case did not turn out well for the judge who did that. And if you go back and look at the case, I might dig out that video and put the link to it. But when I do research, I research cases. I researched as many cases as I could find on the Massachusetts on how they handle jury instructions after I saw what they did to, on, especially including lesser offenses. And there are specific things that has to be done and instructed when there's lesser offenses. And specifically, I went after cases when notes were be presenting to the judge, went over the whole, TUI charge. And there was a case that I did find that specifically when a judge blocked the defense counsel from seeing the note. And it was strongly admonished by judges on appeal. So I think they definitely would have a good argument before any appeal court at that point if they have to go to appeal court. So we'll pray that they don't. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. The court indicated the jury was in an impasse. Once the jury was seated, the court then read the jury note verbatim in open court and without providing an opportunity for defense counsel to be heard, so no fault of theirs. The court declared a mistrial and excused the jury. In short, neither defense counsel nor the defendant consented to the mistrial. Actually, I think at one point he did ask for the TUI charge to be read, and I said that it's bad that they should not want them to seek that, because if they come back and they had convicted her, which sounds like at least some of them were willing to, they can't argue that they were coerced because you went along with the TUI charge, and that is something that's just a strategy that they have to choose. But they did not consent to the mistrial. And even if they had consented to the mistrial, if they're not being given something, if anything's being withheld from them, they would still have an argument in appeal court. And especially with the case that I found where judges were admonished for not showing the counsel the notes. That's just, it's not accepted by appeal courts for judges to do that. While the juror's note, as read by this honorable court, indicated the impasse was on charges, it did not say whether the charges were those within count 2, the multiple ways to find guilt on count 2, or extended to other counts. The affidavits attached herein indicate the former, not the latter. So the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges in the indictments. And of course, it does appear that that was pretty deliberate. The following day, on July 2nd, Attorney Jackson was contacted by a juror in this matter. I think that might have been the day that somebody commented to me, and I think I mentioned that in a video also. I have to go back and look through my videos to see when that happened. But so whoever said that to me was somebody that probably knows them. But anyways, they didn't clarify their comment, so stated she wished to inform him of the true results of the jury deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty to second-degree murder. The one where he said she beat him to death with no presentation or even discussing beating him to death throughout the whole trial and through the media. Yeah, that's what the second degree was about. She beat him to death. And by such assault and battery did cause his death. I mean, I'm just like, why is the media hiding that? Anyways, yeah, go watch those instructions he gave on second degree murder, and it wasn't what was presented in the booking video of what second degree murder was. Anyways, as I was. Yeah, that's right, Risa. Juror A was emphatic that count second degree murder was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime, meaning beating him to death. That was just ridiculous. I'm going to imagine that made them angry. Like, how dare he not only discuss beating him to death, but you argued that he wasn't beat to death, that the car caused his injury. Now, how are you going to come at us was she beat him to death. They were just like, oh no, none of them, even the ones who were split on the second charge, were like no across the board to that one. That was just ridiculous. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury death, which is interesting because I don't know how she could have been guilty of the one but not guilty of the other. I would like to hear, maybe at one point they'll discuss that. They don't have to, but maybe they'll come forward and talk about that. Anyways, so she did not leave the scene. She did not do that. Okay, so that probably, they felt like, some of them felt like she did it, but it was accident. She wasn't even aware that she had hit him, which to me, that's how I took the voicemails of her being just raging at him, like not coming home, not calling her back, and just, it was not, I think it had the opposite effect of what he expected. It had the opposite effect of, she's like this horrible person, and see how she's mad at him, see how she hated him, and all this other stuff. And everybody was like, yeah, man, she's just mad because he didn't come home. She didn't know why. But some of them felt like she didn't know why because she was so drunk she hit him and didn't know. I think that's what some of them felt. But, the rest of them, like, the other part, were like, no, she didn't do it at all. And they didn't buy the tail light theory. Like, they probably believe something else. Maybe one day we'll know what they thought. But I know what 80% all I believe, and I'm one of those 80%. Another day later, on July 3rd, 2024, Attorney Yannetti was contacted by two different individuals, informant B and C, who had received information from two distinct jurors, herein Juror B and Juror C, both of whom were part of the deliberating jury in this case. Informant B sent attorney a screenshot he and she had received from someone hereafter named intermediary B of text messages that intermediary B, we'll just call IB, had received from Juror B. In that screenshot, Juror B texted the following to IB. It was not guilty on second degree and split in half. See, that's what I said. I called it. I said, I think somebody was like, oh, it's one juror holding out. Bull. I said, it sounds like it's split down the middle, and I was right. Not that matters. I'm just saying that, somebody was spreading this rumor about one juror holding out. I'm like, that's such nonsense. Because, the jury foreperson said that they were pretty much, the way he worded it, it just sounded evenly split. Split in half for the second charge. So half of them, 6 of them, felt like she may have accidentally killed him somehow. And then the other 6 was like, she didn't kill that man at all. I don't believe it. And split in half for the second charge. I thought the prosecution did not prove the case. No one thought she hit him on purpose, or even thought she hit him on purpose. Informant C had been in contact with another individual, IC, who is a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial, which they're allowed to do after the trial's over. Informant C sent attorney Yannetti the below screenshots of her text messages with the intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C, no consideration for murder to manslaughter. Started polling at 6-6 and ended deadlock at 4 no, 8 yes. So somebody was able to persuade in the end to take it from being evenly split to 4-8. Informant C, interesting. If it was no consideration for murder too, shouldn't she have been acquitted on that account, for that count, and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. See, I think they were talking about the jury verdict form that even they were upset about. And this judge who was like, there's nothing wrong with her form. And then there was a whole bunch of stuff going online. And then she went back and changed it. So even the jurors are saying that verdict form was confusing. Anyways, so what it looks like to me that they're saying, intermediary C, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on. And that instruction paper was very confusing. So the argument, the jury's unanimous conclusion that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes reprosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Taylor 486, Massachusetts, it's a 2014 case. Rather, the court must determine whether the action actually represents a resolution, correct or not, or some or all of the factual elements of the offense charged. That's the Babb case, 1983. The mere presence or absence of check marks on a form is not dispositive. That's a Massachusetts case, citation omitted. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final, unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. See Alex Jackson. Juror A was emphatic that the count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Thank you, Jesus. I'm just so happy that they actually did. You know what this reminds me of? Just give me a little sidebar here. Please, please, please. Yes, I used that word. Yes, I did do that. You remember the Pixel movie? Did you see the Pixel movie? It was like, I think it was like it was about Atari games. And so there was this group of gamers that were like fighting for championship. And so these pixels come to life and they're like taking over the world. It was a crazy movie. But the interesting thing that happened in that movie that I have used as an analogy through a lot of things, especially the media when they try to misrepresent when there's legal stuff going on. And in that, there's this guy who cheated, and he claimed somehow or another he got the championship of a game, and he tricked everybody to believing that he won. The guy that he defeated believed for years that he had lost in that big championship game. And in the very end of the movie, he admits that he did win. And so that's what this reminds me of. It's like they cheated. It's like he won, but he wasn't going to let them know, you know? I don't know why. That's what brings to mind. Anywho, so sorry about that. And anyways, thanks for sticking with me if you're still with me. It was not guilty on second degree. No one thought that she hit him on purpose or even thought she hit him on purpose, reflecting Juror C's statement relayed by intermediary. I don't know why I'm having a problem with that word. Too many vowels. Good gravy. That there was no consideration for murder too. None, guys. How dare he say that she beat him to death? And all this time to the media and all this time through the trial, argued with all the experts, the best experts in the world, that those injuries were not caused by a car. He wanted to argue with them. And then he has the audacity to present to a jury, oh, in case you don't believe that theory, here, find her guilty of this. She beat him to death. I'm like, the nerve, right? So, anyways, yeah, they said no to that. Thank you, Lord. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would to be elevate form over substance in a manner prohibited by the foregoing United States Supreme Court, Supreme Judicial Court precedents. So I think what they'll have to do, she will have to correct this. She'll have to basically poll the juror, whatever, bring that back in. But if she just digs her heels in or whatever, I think they'll win on appeal. She was like, nah, you'll have to fight for this. We'll see. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. I think this is a case that I had brought up. I'll have to go look in my video. 566 U.S. at 60304. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that double jeopardy clause prohibited reprosecution for capital first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. Let's see what this judge does. The jurors' deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination that persisted through the end of deliberations. The only movement that they had through all of their deliberations was going from 6-6 to 4-8. Even assuming arguendo, and contrary to the foregoing, this court finds that the retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. This 2021 case, Tinsley case. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections. So if they don't go by the double jeopardy clause, Massachusetts will be stripped of that, denying that, because I don't know why any state thinks that they don't have to give what the United States Constitution promises every citizen, like, right? I don't know why they think they can do that. Anywho's, onward. Re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. So here's, like, I'm not hearing a clear, so far, we're almost at the end of this document, I'm not hearing a clear, the jury sent the message to the judge that what they were, hung up on. And so the appeal court will have to decide, well, did the judge have a duty to make it clear what they're supposed to do when they find not guilty? Because remember, she had put not guilty on, in the end, Unetti and Jackson had argued specifically over the verdict form. That was the big thing. And in the end, what the verdict form read was not guilty of second-degree murder or any of the second lesser offenses. So he actually put it an all or nothing. He's the one that made it an all or nothing. So he may have hurt his own appeal, but we'll have to see. Because beside each and every charge should be a guilty or non-guilty. That's by reason of common sense how it should be. But for whatever reason, their court provided form, which that was the point where Karen laughed, because she literally tried to get Unetti to, like, be pitted against Jackson and disagree with him. Like, she's like, certainly you practice here, you saw it, right? And he's like, no, Your Honor, I've never seen it before. And I guess that's it. At some point somebody said something in the courtroom, or Karen laughed about something. But in the end, when they came back in and they changed the jury verdict form, it read at the top, not guilty of second degree murder or any lesser offenses. And from what I recall, I didn't see not guilty on each charge, which is the way it should have been. So by his own agreement to the judge that was acceptable, and actually he requested it, I think he might have heard his appeal on this issue here. But that's what my concern is. So we'll see in the end what happens. Because making it all or nothing without clarifying that was a mess. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Now, he did ask for the TUI charge originally. When I think the first time they came back, you have to go back and look. I believe that was Unetti. Now, that's not the same thing as asking for a mistrial. Here, Ms. Reed did not consent to the declaration of a mistrial, rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. I thought I remembered him asking for the mistrial, but I'll have to go back and look at that. I think I will. Because I know that Lowley wanted to force them to continue to argue, and Unetti argued against him. So they may have a problem with that. But there's, even if that's the case, she usually, when attorneys, if they do make errors, even if don't the best attorneys make errors. I mean, people don't make attorneys gods because there's some celebrity attorney that's just ridiculous. But even if they do,